Topic is apex witnesses.
Okay.
So the way we're going to present it is in a recent case that we had where we got to the top levels of the company, the chairman of the board, 5 of the CEOs, and what it takes to get their depositions and how important it can be for you in your case. This is the case Jesse and I worked on. We're still working on it, trying to get the money. We settled. But it happened October 15th. When was it?
October 23rd.
23rd, 2015. So this is a long time ago. But it was an incredible battle. So why don't you just start talking about what happened?
Yeah, so today, got a little roadmap and outline here of what we're going to talk about. We're going to talk about the power of apex witnesses and how we use them to get the settlement of $1.8 billion and what it took to get there. Some examples, including a deposition clip, which we'll go through, and you'll see Brian cross-examining the chairman and CEO of Sempra Energy, and how to overcome the objections to an apex witness. If you ever try to depose a high-level person, the defense will always come forward with an objection, and you have to meet a certain burden. So we'll quickly touch on that too. Okay, the power of apex witnesses. So it's a little cartoon. People are our second most important asset and our first money, I suppose, because every high-level executive, as Brian can attest to, is concerned about the bottom line. And so, for example, Brian, you want to tell them about, I didn't get the clip, but you could talk about how the CEO of Sempra was tracking the stock price.
So this huge tragedy happens. There's all this bad stuff out about the company. 10,000 people have to move out of their homes. This leak is going on for 111 days. Smells like rotten eggs. People are getting headaches, nausea, dizziness, bloody noses, and a lot of kids had to be relocated. Their schools were closed down, etc. So, what was it? I forgot what we were talking about there.
The CEO is tracking the stock price.
So the CEO, and then we get all these emails, but we don't get the good ones. And then, I don't know if we get to that later, but this Deborah Reed was the chairman of the board and the CEO of Sempra. Sempra is the parent company for Southern California Gas Company. And basically in California, there's Northern California's PG&E for utility, and Southern California Sempra, and underneath that is SoCal Gas. So they provide the gas for everybody. And so they also, utilities have a great benefit in that they're able to basically go to the Public Utilities Commission, which is appointed by the governor, and they make a presentation of how much money they need to operate, because they're a quasi-governmental entity, so they're funded by the ratepayers. So they go to the board and they say, we need this and we need this and that, and they submit declarations, and they don't really cross-examine, and they get, you know, hundreds and hundreds of millions of dollars, which they use for their operating, because they have smaller margins, because it's not huge margin utility. Their stocks pay good dividends. So a lot of people are investing in utility stocks, and in fact, people buy them for the dividends, because they figure the utility's never going out of business because they're being funded by the government. Although PG&E that's a little different, but their bankruptcy was not so much a funding as problems. And so Debbie Reed, we were able to do a graph, like every time something happens, where the stock price was. And she was daily, and she's going to the Wall Street analysts and talking to them and pitching the stock, and they would send people back to say, oh, this is no big deal. Nothing's happened, because they're trying to save the dividend and the stock price.
And the stock price plummeted during the blowout. So she was having her whole team go out and track the stock price basically every single day. And at the same time that she was doing that, we had emails from her hammering the CFO of the company about how expensive it is to relocate all these families who were our clients, relocate them from their homes to hotel rooms and corporate housing, and pay for their meal expenses, and she's hammering the CFO constantly about it. And we'll get to a clip. The clip ultimately that we're going to show shows that she actually had no clue what the health impacts were at the time she was
And
hammering.
so one of the big things they're telling the market is no long-term health effects. The Department of Public Health already determined that. Well, they never even investigated it, but they were saying it. And then, I don't know if it's on the slide, they spent more money for public relations, and they went from, what's the spin doctor's name?
Citric.
Michael Citric. He's like, Harvey Weinstein, people that are really in trouble, they call Citric. And then they had about 9 other PR firms, and they spent over $100 million for PR, yet they spent less money to take the blowout to cap the well, about $90 million.
Yeah.
So they spent more money to get good publicity than they did to stop the well that was leaking for 111 days.
So as we were developing the case, I'm going to switch gears to the obstruction, which leads to the apex witnesses. As Brian mentioned, they were withholding 150,000 documents from us on their privilege logs. They were making bogus claims of privilege, and we just fought them again and again. We must have filed maybe 20 to 25 motions, just trying to get these documents. And the documents ultimately revealed that the highest levels of the corporations were involved on a day-to-day basis, involving our clients in the blowout.
Well, when you're having a blowout of a multi-billion-dollar company, the chairman of the board and CFO, they're going to be involved. That's going to get their attention. And they're writing emails back and forth saying some of the worst things you could imagine.
Yeah.
I don't know.
So we discovered this, that we went to the court. The court eventually ordered trial counsel for defense at Morgan Lewis and Bacchus to submit a declaration under oath saying that he personally reviewed every single document that was on the privilege log. And she explicitly told them, I'm putting your credibility on the line. So after they did that the first time, we discovered that they were lying, continuing to lie about the privilege claims, and we busted them again. So she actually made them do it again, go back, and they had to file 2 declarations. We got 150,000 documents from it. So I'm going to quickly jump to...
well, that wasn't the best part of the order. The best part of the order was, you're not going into the orders, right?
No.
Was we had already taken maybe 200 depositions. Because number one, they can take all the depositions over again that they want. Number two, if there's any deposition, the document raises a colorable claim, they can take that deposition too. And you're going to pay for the plaintiff's time to prepare and to take the depositions. So we're like, then we start taking everyone's deposition, and we're finding, but we didn't really have all the good documents, and we're finding out more and more stuff, and we're identifying more and more witnesses. So this is all during the pandemic. We probably did over 300 depositions.
And that was the great part, because the courts were closed at this point when we got the order.
We start doing the Zoom, and then they pull this bullshit. They go, oh, we have a policy that Zoom is not secure enough, so we can't do any Zoom depositions. This is in the beginning of the pandemic. And the judge shut that down real quick.
We actually went to Zoom, who gave us a white paper on how secure Zoom is, to give it to defense and SoCal Gas and tell them how.
So now we're in the pandemic. We got all these documents. We're doing Zoom. We're trying to learn about Zoom depositions, and that's where we started doing. Like I would be in my office, and Jesse would be in his office, and other lawyers in the case would be around the country, and we use this app Slack, and you should look into it for joint use on a case. So I'll be answering a question in my office, and I have a standing desk, and then they would say, ask this, and it would come on my Apple Watch, and I would look, and I would just ask the question, and they're like, and it was a great collaborative effort to do these depositions. So let's talk about how we got there.
Well, and so these documents revealed that, as I said, the highest levels. And what we actually ended up doing was, I mean, the case involved millions of documents, and we got 180,000 more. And we ended up showing the judge, comparing what the document production looked like before these documents were produced off the privilege log, what it looked like after on a witness-by-witness basis, and showing that, you know, when it came to the CEO, there were like 200 documents before, okay, out of 1 million documents. After the orders from her, there were 3,000 documents involving the CEO. So we literally showed the judge how they were trying to conceal the highest level executives' involvement. And obviously the purpose of doing that is because these apex witnesses bind the company and are managing agents for punitive damages. And that was one of the biggest claims we had.
And in California, oh, you got the code next, right?
I got the code, yeah.
So in California, under Civil Code 3295, you need to have either ratification or approval or the act being done by a manager, agent, managing
Officer, director, or managing
and all
agent.
these people are at that level. So
Definitely.
whatever they say, they're totally authorized, they can bind the company. And if they did something, that's ratification for punitive damages, which was a big part of our case, the punitive damages.
Huge part of our case. So the emotional reason, so obviously when you go in and you're talking to the CEO, there's an expectation that they know what's going on at the company. And I think the jurors expect the CEO to know what's happening at the company and to give answers for the conduct of the company so they can be accountable for it. What we're going to, in the clip we're going to show, these executives pretended to know absolutely nothing, even when they're on emails being informed on a daily basis. You know, the blowout happened. They were getting daily emails of every event every single day. And they formed this crisis management team with all the highest level executives at Sempra and SoCalGas. And they would come into the depositions and either pretend they didn't recall, I don't know. And we're going to see a clip where the Sempra CEO does that.
Right, these people, they're getting paid millions and
Millions.
millions of dollars. They got stock options. They get paid. This one lady got paid $20 million to quit. I mean, the amount of money these people make is unbelievable, that these utility people make.
And actually,
And they just keep promoting them up. Even if you're bad, you just keep, and they have, you know, they have multiple subsidiaries, San Diego Gas and Electric, SoCalGas. So they may, you know, you're CEO of one, then you go to another one, and they keep moving you on this track. It's all the same people are working there forever.
go back to the presentation. Okay, the example. So we already talked a little bit about the case. In October 2015, the oil and gas well blew out. This is the equivalent of using 190,000 Los Angeles homes. That's how much they use on an annual basis, came out of this well and into this community. Let's play this video. Brian, you want to talk about, so Brian, early in the case, immediately realized, how are we going to show?
How are we going to show, like, prove this when it's gone? So I got some guy to get a drone and a FLIR camera, try to document, see what it would look like. Well, lo and behold, this is what we get, right? You could see it all coming up, but the naked eye, you couldn't see that.
Methane is colorless, and it has an odor because they add it, but it's colorless, so you can't see it to the naked eye. But
So
the
the
FLIR
FLIR
camera lets
camera
you see it.
picks it up. Now,
You'll see in a minute, you'll see the homes.
it looks like Chernobyl. And actually, there's emails saying, hey, you better take that off, some pictures off your website. It looks like a mini Chernobyl.
Yeah.
This is great evidence right here. So every time this case was on the news, they would be playing this. So everybody saw it.
And then it was funny because actually it was part of the documents that they were withholding, but eventually they produced them. And they were internally strategizing. You know, this is the plaintiff's lawyers, us going out, getting evidence. They were strategizing to figure out ways to discredit this. And we got those documents 4 years after we made the video. And they're figuring out ways, they're calling up FLIR being like, there's no way that this could recognize, you know, methane out in the community. They were trying to get FLIR to validate their concerns on a PR basis because this was hitting the news.
This was killing them in the media. Because they're saying, oh, there's no long-term health effects, everything's fine, no problem.
Go to the next slide.
First, you gotta go there.
Okay. Okay, so these are the 5 former, eventually we deposed 5 former CEOs of SoCalGas and Sempra Energy. I think Brian deposed, how many of those people? 4 of the 5, or 3 of the 5. I deposed 1, and there was another lawyer who deposed another one. And we also deposed 3 members of the board of directors.
including Kathleen Brown, the sister of the governor at the time, who, you know, was kind of helping them. And, you know, she's on the board. Also, Lynn Schenk, who's a U.S. Congresswoman, formerly was the appointment secretary for Governor Gray Davis. And what was the other guy's name?
William Rusnak, who was, you know, he had more disdain for plaintiff's counsel in his deposition.
And then, so these people are very skilled. I mean, they're all media trained. We got into all that, how they do the media training. They're, you know, these CEOs are going, giving big speeches to schools, to board members, to investors. I mean, they're very skilled on not answering questions. And they teach them how to do that. And we were able to, so this one was a Debbie Reed. So Debbie, is this Debbie?
Okay, so we'll talk, this is Debbie Reed right here.
This is Zoom too.
Okay, so this is Brian deposing Debbie Reed, the CEO of Semper Energy.
Oh, by the way.
And wait, I just want to, I'm going to play some, stop, and then play some. And okay, go ahead, Brian.
I deposed 5 days.
5 days, yeah.
On her, 6 on the other one. And they would all be not in a row, because we kept wanting to get in a row and they wouldn't let us. So then we'd have all this time to prep to go back the next day, the next, you know, month later.
Until the judge ordered day to day.
Then the
I
judge
don't know what's
said
wrong
day
with
to day.
the sound.
We need the sound.
And then he wrote to you and told you, this was on November 23rd, that we're working with local media and health agencies to help residents understand there is no health concern related to the gas leak, correct?
Yes.
How was your company working with the media to help residents understand there were no health concerns related to the blowout?
Yeah, I don't know, I didn't write this. I don't know exactly what Gas was doing with the media.
Okay, so you're unaware of what SoCal Gas was doing when they were working with the local media and the health agencies to help residents understand there is no health concern related to the gas leak, correct?
Yes, I don't know what they were doing, working with the local media. I don't know precisely what SoCal Gas was doing.
How could Southern California Gas Company know that there were no health concerns at that time if they didn't disclose the chemicals involved?
I don't know.
How was it, ma'am, that Southern California Gas Company, who was under the Sempra umbrella of companies, knew within 30 days of the blowout that there was no health risks to the concerned residents?
I don't know if they were working with the health agencies, so I believe that they would have been working with the health agencies to determine that.
My question was, how did Southern California Gas Company know that there was no concern for the local residents for their health related to the gas leak within 1 month of the gas leak?
I don't know.
Can you pause it for a second?
Can you give me any info?
So that was an example where the I don't know is the highest level CEO of Semper Energy having conscious, and Brian, we pivot to it, but having conscious disregard for the safety of the people.
But conscious disregard is the key for the punitive damages in California, the language in the statute, which of course these big firm lawyers didn't even.
So we, in this case, when we got to that level, we embraced the I don't know. That is the conscious disregard. The fact that the Semper CEO who's making decisions about what to do with these people's health and safety had no idea about what was in the chemicals, what was happening in the local community. And at the same time, they were spending $100 million on PR to convince the community This is safe to be here. You don't need to relocate. You can stay at home. So the I don't knows were powerful admissions.
Additionally,
punitive damage.
in emails, she's saying this, we're doing this, we're doing this, we're doing that. And then it's not, I'm saying, how do you know in 30 days there's no long-term health effects?
Right.
Explain that one to me. Which
this-
doctors told you that?
And they, at the same time, they're saying this was an unprecedented event. So there's not even something you could look to say, oh, in the past it didn't harm these people or
And
whatever.
eventually, we found a study where they had a property they owned down in Mobile, Alabama. They had another leak of this chemical in the water, and the CDC did a study that supported short-term and said, you can't determine yet whether there's long-term effects or not. And they had all that information.
It was their facility. It was Sempra Energy's facility. So it had happened on her watch. Let's go back to the deposition because you'll see Brian pivots to trying to get the admission on conscious disregard directly from the Sempra CEO. So you can keep playing.
You got to go back a
Okay.
little. You see where I am.
SoCal Gas was doing when they were working with the local media and the health agencies to help residents understand there is no health concern related to the gas leak, correct?
Yes, I don't know what they were doing, working with the local media. I don't know
Can you fast
precisely
forward?
what SoCal Gas was doing.
How could Southern California Gas Company that there was no concern for the local residents for their health related to the gas leak within 1 month of the gas leak?
I don't know.
Can you give me any information how you could already know that there will be no problems for these residents and your customers as a result of the blowout that has now been going on for 30 days?
My understanding is that the health agencies were monitoring the situation and were advising that the concentration, that the chemicals and concentrations were not a health risk. That's my understanding.
Well, would you agree for someone to say that there was no health risk to the concerned residents if they didn't know that would be despicable?
This,
If you intended to mislead, I think it would be despicable.
despicable is something you have to
Intended
prove
to mislead.
for punitive
Well,
damages.
if you misled without having all of the information, would that also be irresponsible?
Yeah, I'd have to know what information you had and didn't have and what the intent was. I couldn't answer that question without knowing more.
Was there a purpose of public communications to help the residents understand what was going on?
That was, yes, one of the purposes of public communication.
Well, if the local health agency, the LA County Public Health Bureau, had told Southern California Gas that there were health concerns and Southern California Gas disregarded that, that would be despicable, wouldn't it, ma'am?
Again, I think I'd have to know more information to pass judgment on.
If the public health
Can you
Bureau
pause it?
told SoCal Gas that there was a health.
So again, so despicable is what you have to prove under 3294 for punitive damages, that the conduct was despicable. So Brian's questions were going directly to get an admission from the Sempra CEO, just quoting the statute, which is something I learned from Brian in this process. You just, if you get that admission, just the actual ultimate fact, that is how you can prove up your punitive damages rather than sort of, that's the direct admission, as Keith Minnick was saying earlier today. I also think it was really effective how she wouldn't answer whether it was despicable to mislead the public about the health impacts. I mean, this is the CEO of a public company who is not willing to pass judgment, in her words, on what her team was doing, which was misleading the public. And finally, when you're dealing in these cases, so there was this huge PR thing, obviously, and Brian hit on the purpose of that, which was to inform people who were making decisions about their health and safety during the blowout. And it was clear from the CEO of Sempra that admission was really, they kept saying no one was relying on what we were saying. That was their whole defense to fraud, okay? No one was relying on what we were saying. We were putting stuff out there, but none of these plaintiffs can prove they heard anything from us. But when you get that admission from the Sempra CEO, that was critical to show they intended for everyone out there to rely on what they were saying to make those decisions. Keep playing. I don't know if it is, oh, there we go.
Just play right there.
Yeah.
Okay, I understand that.
Would it be despicable for Southern California Gas Company to tell people in their public communication that there was no health concern?
Again, I'd have to know the facts for that, given the limited facts that you use in your example. I would not consider it appropriate, but I'd have to know all of the surrounding facts.
What surrounding facts would you have to know whether it was despicable if the public health agency told you there was health concerns for you to tell people there wasn't?
I'd have to know what levels of exposure they were saying at, I'd have to understand what their statement was versus the statement that you made in your comment.
Well, if the public health agency told SoCalGas there were health concerns, should you disregard that?
No, you should not disregard that if the health agency said there were health concerns.
You agree that your customers had a right to know of whether the chemicals being released could cause them to be ill or have health concerns, correct?
I agree that customers should know whatever information was available between the company and the agencies.
Does that include whether or not there were health concerns, ma'am?
Yes.
Would you agree with me that telling people there's no health effects, as was stated here, would be despicable if the county health department told you the exact opposite?
If it was that black and white, then it would not be appropriate. Yeah.
And it would be despicable, wouldn't it, ma'am?
I don't know how. Despicable is not a term I use, so.
Well, what does it mean to
We-
you, ma'am?
All the witnesses were playing word games.
Those would be the terms I would use. It would not be appropriate.
It would be in conscious disregard of the rights and safety of your customers if you withheld from them information about health concerns, or you misrepresented what the county public agency had said, correct?
That if knowingly you did that, it would be in conscious disregard to your customer's concern. If knowingly you did that, I'd have to know if there was that kind of knowledge.
I think that's the end. So you could see how you went from the underlying facts of them making a statement, we're trying to tell the residents there were no health concerns, and all the way to the fact that it was despicable conduct and in conscious disregard of her customers. And you have the Sempra CEO who's admitting that for our case. And then Brian, later in the deposition, we had, earlier than that time period, there was actually an order, which had never happened in the history of Los Angeles, an order put out by the public health agency, LA County Public Health, that literally said, there are health concerns associated with this blowout. If you have symptoms, here's what you can do to take action to protect yourself and your family. And so Internally, we were seeing that